Yeah, thank you very much again. Before starting, first of all, I would like to accept the invitation from Mr. Ming Feng to come to Taiwan physically. So please note this down. I'm more than happy to join the next seminar in Taipei. Secondly, I would also like to say a few words in response, or in addition, complementary words to the very interesting presentation by Mr. Ming Feng. Indeed, in his comparison of the EU system and the Taiwanese system, because I believe in understanding basic principles and rationales of each of the system, it is facilitating the understanding when we consider specific issues, such as the protection of new emerging designs, or as we are now going to address the protection of interior design. As mentioned by Mr. Ming Feng, is that the EU design system is fairly unique in its approach towards design system. The EU design system is not a design patent system, and it is not a copyright design system. It is indeed a unique system on a global basis. For a patent design system, for instance, it is typical that design patents as invention patents or utility patents are examined ex officio at the offices. And this is, as mentioned, not the case for the European Union. And in consequence, for instance, design patent systems typically require that the design is applied in showing all its perspectives, that a full disclosure is done for the design applied for, so as to allow the ex officio examination. And I have received a question ahead of this seminar on the design system, on our registrations of interior designs, which are possible just merely by showing one perspective. And I understand that the question from the point of view of a design patent system is, can you actually just file a design by showing one perspective? And for the EU, the answer is yes, because we are not following a design patent system. We have our own design approach. So what is the EU design approach exactly? At the rationale, at the heart of the design protection for the European Union is to protect the design excellence, the visual appearance of any types of products across all industry sectors. So design is seen also as a marketing factor, as a distinguishing feature in the commercial market. So this is the overarching rationale of the design protection system. And it shows in various of the notions of the design systems. To give you an example, when under the EU design system, the similarity of these two designs is compared, the examiner has to examine it from the point of view of the informed user, of somebody who is actually using the design. So this is a reflection of the fact that the design is considered as a marketing factor, as a commercial reality. Another example is that the disclosure of the design in the EU, it applies and it can be disclosed anywhere at any time. But there is a limitation that if industrial circles cannot be aware of the disclosure, then it does not count as a disclosure. So again, here we are shifting the focus not only on the user, but also on the industry concern. So these are just examples to show how this different rationale plays out in various aspects. And it also plays out in the topic I'm going to address now, which is interior design in the European Union. Next slide, please. This is from my previous presentation. As I have said, this is an essential characteristic or distinction of designs which is not reflected in the current design definitions of the European Union, but it's a common distinction designers draw between product design, graphic design, and indeed the design of spaces of an environment, which is a requisite also to recognize virtual reality designs. Next slide, please. So here we go. Now, here I talk to you as a lawyer, the statutory definitions of the EU design system. I don't want to go into too much detail, but just again to explain the origin, what is at the heart at the current system and how we can interpret it to address new types of designs, including interior design. The central notion of the design protection is that a design applies to an industrial or handicraft item. So this is, of course, a notion which is still bearing in mind physical products, tangible products. But the statute includes various examples of what it considers a handicraft, an industrial or handicraft item, amongst others, graphical symbols. So already you can see from this exemplary list that we cannot understand necessarily industrial and handicraft items in this tangible sense. Also a graphic, as I have explained earlier on, can be a design. This list of examples of the statute is not exhaustive, meaning it is just it just gives examples. And in practice and in case law in the European Union, one example of a design which is also recognized is that for sets of articles. The typical examples being sets for cutlery, knives, fork, spoon, which are, of course, in the marketplace designed having common features and they function together. Another classical example is that of board games, where the design also is composed of separate items which work together. So these sets of articles are also recognized as one industrial and handicraft item under the EU system. And it's interesting to compare this protection for set of articles also with the topic of my presentation, which is interior design, which typically also includes separate elements, such separate pieces of furniture, chairs, and so on, which are also not fixed as one single item, but they are separate items which together form an overall appearance which can be protected as a design. So there you can see already that we have, based on this, a springboard also to recognize the protection for interior design. And as I have said in the beginning, concerning the rationale of the EU system, we can not only stick to the wording of our statutory definitions, but we also have to bear in mind what the design protection aims at. And as I have said, it is to protect designs across all industry sectors and to give design as a design protection as a marketing factor. And for sure, this also can apply for interior design. Next slide, please. But as I have said, design is not expressly mentioned in our statutory definition. So the next slide shows you a little bit also our development, because when the design system in the EU was instituted, from the outset, it was not clear whether or not to protect environmental design. And still today, when we compare EU level and the member state level, the 27 member state, the interpretation of the law is not harmonized. So this is what I show you here a little bit, the development of the EU design system on EU level. There you can see on the left-hand side an example for a design, which is in fact a single item, a single industrial handicraft item, this restroom, which you may find in a student home or in a train or whatever it is. which is one physical product, creating a space. So this easily fits under the definition of what is an industrial handicraft item, but it creates a space. So what is then the material difference to the next one, which is the actual space? Now, can you go back, please, to the slide? Sorry, I mentioned the word next, so my apologies. So if you stay with this one, so the step to the next protection of interior space is fairly close. And the only difference being that in this example, the chairs and the table, they are separate items. But again, bear in mind the protection for set of articles, which is recognized as well. And when recognizing this physical room, of course, we can also recognize the virtual room as shown in the third picture. And now, next slide, please. And by this, I want to give you another reason why the EU regime has come to acknowledge interior design. And this was also interestingly mentioned by Mr. Ming Feng, which is the notion of a get-up. When you look into our statutes, get-up is one of the examples given for what is a design. Now, get-up in the natural meaning in English refers to the overall packaging design. This is the natural meaning of get-up in my understanding. However, according to the Locarno classification, you find get-ups also in class 32 for the class for graphical symbols. And in the Locarno classification, get-ups are also, as you can see on the slide, determined as the arrangement of certain spaces, the arrangement of trains. And all of this together, the rationale of the EU design system, the fact that the get-up is mentioned in the current statute, the fact that Locarno classifies get-up to be understood as an arrangement of an interior, all of this together has led to the fact that on a European Union level, interior spaces are recognized as designs. And I'm going to show you now on the next slide a few examples of what we can see in our register being applied. Next slide, please. So here you find typical examples, and this is, of course, you find it, the examples for interior designs, you find it typically for interior designs which are in commerce subject to franchising, i.e. to reproduction. And therefore we see a trend in the EU register for filings in restaurants, which are often franchise-based, of course. You find it in the EU system for hotels, for fitness facilities and other interior spaces, which you find across the EU, even on a global basis. The look and feel of the interior spaces is very much the same. So here you find just some examples for registered EU designs. And I have chosen these ones specifically to address another the difficulty I have mentioned before in this graphic showing the space as a single handicraft item, as a single space without separate elements, and then including the chairs and so on. So on the left-hand side, you see an example of a reception of a restaurant, I guess, or maybe of a hotel. And in fact, if you look at the design view, it's just a single view. As I have said, we do not need in the European Union more than one view. You see just merely one chair on the bottom left-hand corner. It is, I believe, from your point of view, there is one chair. But for the rest, it is basically, it can be perceived as a single item. It is physically a unity. And then when you move your eyes to the next one, of course, there you can see the chairs, which are the movable items. You can see plants appearing, which as such are not cannot be designs unless they are artificial plants. But what the design here is about is indeed the arrangement. It is the overall impression, the look and feel of it all. It is not, of course, the protection for individual items as shown in this space. Next slide, please. So here we can see, as I have said, other examples on the left-hand side for the hotel interior, and on the right-hand side for, I believe, a gym. These are all registered EU designs. Next slide, please. And before moving and closing with some words on copyrights for interior design protection, let me expand the pie a little bit by also noting that under the EU system, interior design can also be protected as a trademark, of course, a non-traditional trademark in the form of a store layout. And you can see here an example, and you may well recognize this as the interior of an Apple shop. And this is a representation of a trademark, which indeed can be registered in the European Union according to a ruling of the Court of Justice, which was faced with this question: can the layout of a shop work as a sign in the trademark sense, i.e., as a commercial source indicator? And the answer given by the courts of justice on this legal issue was, in principle, yes, provided that the layout, the design, the interior design departs significantly from the norms or customs of the economic sector concerns. So this is what we call in trademark law a significant departure test, which is applicable for most non-traditional trademarks. Another example for a non-traditional trademark would be a shape mark, where the shape of a product as such can work as a sign. And also for such a shape mark, the test would be to answer the question whether it can be inherently distinctive. The question would be whether or not that shape departs significantly from the norms of the sector. Same standard also for the layout of a shop. If it departs significantly from the norms of the sector, so for a shop in this example, then it can function in the European Union as a non-traditional trademark. Next slide, please. But concluding here with the question to what extent interior design is also accessible for design protection, as addressed by Adriana in the presentation beforehand, in the European Union, we do have the protection of the principle of dual protection, of protection accumulation, which means that the protection of the interior as a design does not per se exclude the simultaneous protection by a copyright. And this is also, and I'm fully aware of this, different in fact in most jurisdictions on the globe as far as products designs are concerned, or designs for interiors. If design protection is available, copyright protection by one way or the other is either categorically excluded or limited in time, so that the rationales of the two IP systems are not undermining each other. And this applies most prominently, of course, to the term of protection of copyright, which in the European Union system is 70 years after the author's passing. So in principle, of course, if design protection expires under the EU system as it is designed right now, copyright protection remains available, and this is a distinction to most jurisdictions on the world which regulate this interplay between design and copyright. So here you see just an example from Italy, in which copyright protection for the interior of this perfumery shop was recognized. Now, due to the absence of more time, and also due to the fact that copyright, as mentioned, is national law in essence, despite the fact that we have some degree of harmonization, it depends on the member state concerned to what extent and under what exact requisites the copyright for the interior of a space can be protected by copyright. In principle, it is possible, but the exact requisites very much depend on the member states. Most, I may say, out of the 7 member states are open to acknowledge that the interior of a space constitutes a copyrightable work, such as under the Italian system or such as under the German system. But I beg your understanding that I cannot recount how it functions under all of the member states. So I would like to conclude here my presentation. I believe this was the last slide, but if you can move on, please. One more slide. Next slide, please. So I think there is none. So unfortunately, unlike my previous speaker, you also do not find my contact details on the presentation, but I'm sure the organizers can you provide you with the contact details in case the question and answer session later on will not fully answer all of your questions and you would like to address me, and I'm happy to for a further exchange on this. Thank you very much.